Selamat malam, magandang gabi, good morning, good afternoon, good evening. Welcome to this webinar event, which is jointly organized by the Center for Commercial Law Studies, Queen Mary University of London, in particular by the Alumni Association from Indonesia, Philippines, and Distance Learning Technology, Media Telecommunications collaborate with Hukomonline. Today's webinar title is Merger and Acquisitions in the Tech Sector, the Role of Law, Compliance, and Policy in Shaping the Digital Economy. In this webinar, I am Evgeny Nilsson, replacing Pajari Koncha-Mang, will be the host of the start of today's webinar event. This webinar will consist of two big sessions. The first session will be started by me as host and later opened by the moderator, Mrs. Valentina Tarelli, followed by the keynote speech from Mr. Arca Diratara for 10 minutes approximately. Then the presentation from two speakers, Mrs. Pedro Duarte Batista and Mr. Bratara Damanik separately, where each of them will have 15 minutes to do the presentation, where question and answer session will be held after the two speakers are finished with the presentation. However, questions can be raised throughout the whole session in the chat box menu before the question and answer sessions begin. Then the second session will be started after the Q&A of the first session is finished, where the role of moderator from Mrs. Valentina Tarelli will be given to Mr. Guan Zeng. The second session will be conducted in a similar format, where the three speakers will do their presentations separately first, then followed by a Q&A session before the whole session is concluded by Mr. Guan Zeng. Before I hand to the moderator, on behalf of the organizer and steering committee, I would like to express our gratitude by saying thank you to all of the people who contributed to the success of this event, where I will start with the distinguished guest speakers like Mr. Arca Diratara from Hukomonline, Mr. Pedro Duarte Batista from Vieira de Almeida, who also lead content of this event, Mr. Bratara Damanik from HHP law firm, Mr. Miguel Damayakayak, Mrs. Inna Palekova, and Mr. Ferdowsi Ferouz from the University of Barcelona for sharing their knowledge, view, and experience to all of us in this event. We also would like to say thank you to Mrs. Catherine Taylor Bennett and Mrs. Rachel Owusu-Dome from the CCLS Alumni and Development Team in London for technical and promotional assistance of this event. Mrs. Valentina Tarelli and Mr. Guan Zeng from HCMC University of Law as the moderator of this event. Me, Evgenia Nilsson, who replaced Mrs. Pojari Kuanchimang as the host of this event. We also would like to thank very much all the colleagues at CCLS Committee Indonesia Chapter, such as Mr. Firdaus Firdaus, the initiator and the lead project of this event, Muhammad Iqbal, for the eFLAR and virtual Zoom background, Lavira Fitriana Usman, Jennifer Karina, Madasita Lokitasari for technical and promotional assistance, as well as the rest of the members of CCLS Committee Indonesia Chapter and CCLS Indonesia Community. We also would like to express our gratitude to our colleagues, Mr. Voltaire from the CCLS Philippines Chapter and Mrs. Valentina Tarelli for approving the collaboration idea and speaker for this event, for promotional assistance, and for their presence during the event. We also would like to express gratitude to colleagues from Hukomonline, in particular Mr. Arca Diratara, Mrs. Dian Maya Safitri, and Mr. And Mr. Ilham Munal for approving the collaboration idea, promotion, and providing a keynote speaker. Last but not least, we also appreciate all of the participants who kindly enough decided to allocate time to be here, as a good event is determined not only by the topic, the speaker, and the organizer, but also by the presence of the participant. As often people said, the more the merrier. All right, then, without further ado, I will continue by introducing our moderator for this event, Mrs. Valentina Tarelli. Valentina is an alumna of CCLS Queen Mary University of London with an LLM in Computer and Communications Law, graduating in 2020. Valentina is an Italian qualified lawyer and practices as an independent attorney in Milan. Valentina advises clients in all fields of IP, IT, and new technology law, with a special focus on data protection and privacy issues. Her practice focuses on data protection compliance projects, privacy by design and privacy by default strategy, data transfer compliance, data breach management, data protection, impact assessment, etc. Valentina also provides assistance concerning data protection issues about e-commerce, online applications, as well as legal aspects of metaverse, and artificial intelligence. All right, then, from now on until the Q&A section, our moderator will lead the organization of this event. Valentina, the floor is yours.
Thank you very much for your kind introduction, Ms. Eugenia Nielsen, and of course for joining this webinar at the very last minute and the comprehensive explanation that you have just provided to all of us. As we all know, the reason why the CCLS and all the partners decided to organize this webinar is that one of the keys to humanity's survival is our innovation habits. As we can witness from time to time, for as long as humans have lived, that technology is one of the fruits of our innovation, and it helps, or it should help, drive our human civilization. So in this context, the topic of tech mergers and acquisitions, we can call it M&As, may play a pivotal role in fostering innovation, enabling the creation of synergies between companies operating in complementary and or adjacent sectors, which at times it either strengthens the market position of those companies or give rise to new and sometimes disruptive businesses and technologies. So thanks to the use of the internet, massively digitized products and services in many sectors, such as big data, Internet of Things, and now artificial intelligence, we will likely witness more M&A activities taking place in the tech field. That said, among the objectives that should not be disregarded with tech M&As, I believe four are of prominent importance. First, the innovation design of the M&A operations to be directed for the pursuit of a sustainable technology, balancing a more and more digital-driven economy with the solution of human problems. Second, the cross-border or supranational character that such M&A operations many times display. Third, the geographical and geopolitical issues surrounding technology nowadays, as far as cost-worthy technologies seldom involve the processing of data, being those personal or non-personal data, in cases protected even differently from one jurisdiction to another. Fourth, the economic and practical efforts in pursuing M&A operations that can also be sustainable for businesses in terms of compliance with the law and the practices that may vary from one nation to the other, depending on the parties involved in the M&A operation. And five, and last point, the sensitive strategic plan of M&A operations in terms of allocating the roles, the responsibilities to all the parties involved in the life cycle of the M&A operation, taking into account the different legal compliance risks that may come into play in different stages of the operation. So having all the parties preparing for the necessary safeguards to shield themselves from liabilities, which is something directly impacting on negotiations and drafting of M&A related agreements. So that said, on this occasion, the Center for Commercial Law Studies Alumni Chapters, Queen Mary University of London, in particular the Distance Learning TMT Indonesia Philippines Chapter, collaborated with the Indonesia regulatory technology company Hukomonline. I hope to have pronounced it correctly, otherwise I apologize. And they decided to organize this webinar on this topic, merger and acquisitions in the tech sector, the role of law, compliance, and policy in shaping the digital economy. So without further ado, we will begin this first session with the keynote speech from Mr. Arka Diarataram, who is the CEO of Hukomonline, the largest regulatory technology company in Indonesia, appointed to this position in August 2020 after previously serving as CTO since transformation by incorporating cutting-edge technology into the company's products, processes, and strategies. Before joining Hukomonline, Mr. Arcad worked for 5 years at the Executive Office of the President of the Republic of Indonesia, where he spearheaded the development of several nationwide applications, such as lapor.go.id or program at technician or data go ID. And he holds a master's science degree from the computer science program at the Technische University Delft in the Netherlands, funded by a competitive national education scholarship program from the government of Indonesia. Currently, Mr. Akra is leading a project in developing Alex, the first generative AI platform designed for legal research and analysis in Indonesia. This application, this system leverages the power of artificial intelligence and is meant to provide users with fast, accurate, and comprehensive legal insights, helping legal professionals, academics, and everyone seeking to navigate the complexity of Indonesian law. So, many thanks for your participation to this webinar. Mr. Akram, the floor is yours.
Thank you, Valentina, and good evening to everyone and greetings from Jakarta. So my name is Arka. I'm the CEO of Hukomonline. So hukum in Indonesian language means law. So the company has been around for more than 2 decades. So it's founded back in 2000, and our main focus is to provide both the knowledge and technology for our subscriber. So currently, Hukomonline, we are become a knowledge partner for more than 1,600 lawyer and law firm and corporation, basically. So we provide them with the legal database and also the legal analysis of the dynamics from regulation from Indonesia. So for this opening speech, basically, I've prepared a simple slide to give an overview about the trends, and then we'll deep down to the Indonesia M&A market. I just want to confirm whether everyone has can see the screen or the slides.
Yes, thank you. Maybe you can just minimize your screen because it's very big.
Okay.
And center the presentation.
Wait a minute. I think something is not. Wait a minute. Let me reshare it. Okay.
Perfect.
Perfect. Okay. All right. So as Valentina mentioned earlier, I think maybe I'm the most unique person in this call because my background is computer science. However, my business and Hukomonline, we like in the intersection between that two worlds, which is the law and the legal, the law and the technology. So for this session, basically, I want to give some insight on the development of the generative AI in Indonesia and how the technology can change on a different aspect of the legal works. So at first, I want to emphasize like for the past 5 years, specifically after the pandemic era, we see the surge of the use of technology. And in one of the research conducted by McKinsey, it said that in 2021, it said that the pandemic has catapulted the adoption of technology 7 years ahead. So you can imagine in back in 2020 to back 2021, like for several company, I think most of company who haven't adopted to remote working, now they need to subscribe, for example, to Google Meet, Zoom, Slack, and etc. And they need to transform their existing business process, which previously conventional, become more digital and can be accessible to everyone. So with that aspect, it is very makes sense that after the pandemic era, the use of the IT or the spending trend is become higher on the left side of the chart. And following the 2023, when the AI, or artificial intelligence, become more mainstream, we can see the really high spike on back in 2023 until today. However, what I want to emphasize on this, basically AI has been around for more than decades. Is this still Zoom? No?
Yes, you are on.
Okay. Yeah. So that's why we see a lot of adoption in AI, like from the uh, based on the ChatGPT, because now AI is consumable from the end user. But back again, like the AI itself has been created, I think, back in 1950s, but it's something that's still on the research part, or very niche market, I can say. So as we all know, back in when the pandemic, the money itself, or we so-called cash, is very cheap on that time. But then after the pandemics passed out, and then we see that there is some changes in the dynamics of the investment in the technology sector or technology industry. We see that a lot of increase of the capital market from several technology company, and also the leading of the tech window. We see a lot back here in Indonesia. I can say since 2023 or 22, like the number of investment from venture capital to several startups in Indonesia begin declining. And that's why some of the several startup, I can say, is really who's still playing a valuation game, really have a difficult time. And some of them opt to do some merger and acquisition to smoothing their runway, basically. So I think this is the trends that very mainstream and also happening in different part of the world. So as you can see, the global market and merger and acquisition in globally, although there's the spike in 2021 and then a steep decline in the later year, but in 2024, actually there are some bumps, yeah, small bumps to which might be seen as the uptrend, I can say. Uh, but if we go deeper on each region, there's also several interesting progress, whether it's from the North America, Asia Pacific, and other part of the country as well. So what I'm trying to say that although the M&A trend is not as high as in back in 2021, we can say that it's getting there, because in Indonesia, for example, it's very hard to get the fresh investment. Like now, the investor really very selective on looking to invest in startup company in Indonesia. So more and more company or startup in Indonesia is trying to aim for the IPO to get the fresh money. So in order to have a better positioning on the IPO, they tend to merger or acquisition, and which make the prospect of more appealing to several investors. So back in 2004, for example, there's several consolidation. I can say that many of tech company have pursued merger and acquisition to survive intense competition and challenging. Like there's some like TikTok acquire a Tokopedia, who once one of the biggest e-commerce company in Indonesia. And then there's also like several other company who are being acquired, like then to consolidate into one as single entities. And there's also a strategic expansion by large companies, and we see a lot that maybe in the tech center. One of the buzzing news is on the IBM acquiring the HashiCorp, is one of the leading platform as a service in the market, and it backs around 6.4 billion US dollar. So there's also several notable company. What I'm trying to say is there's still a lot of highly prominent transaction happening, and we see that with the tech window, without the investment become really dried up. I think we can expect more and more transaction in M&A. So in Indonesia, we have the so-called the Digital Economy Development for 2030. So it published by the Coordinating Ministry for Economic Affairs of the Indonesia. So they conceive a six pillar to achieve this. So whether it's from the infrastructure, as you might know, the former president of Indonesia, Joko Widodo, or we call it Jokowi, like on his two-term as a president from 2010, until 2024, for 10 years, he focused his administration in building the infrastructure. Like now, in Indonesia, we have the fastest highway rail system in the ASEAN. We now have the several key highway tolls in outside of Java. So Indonesia, mostly populated island is Java, but then Pak Jokowi, the previous government, they invest a lot to building several infrastructure titles in different kind of the island.
Target 2030 itu bisa dilaksanakan apa enggak karena kita ingin tahun ke
Hello?
depan.
Hello?
Someone has the microphone on. Please stay on mute. Thank you.
Yeah. And secondly, I think this is one of the key focus in the current government, which led by Pak Prabowo, was focusing on the human resources. So in his election campaign, and one of several of the key strategy for his administration is focusing on improving the human resource of from Indonesian. So whether it's the low skill worker and high skill worker, and even in certain extent, the government really allocate a lot of money to finance one of their key program, which is the free lunch for every student in Indonesia. And it really get a lot of buzz currently, like how exactly it's going to happen, and like how big the budget is required to do that tremendous scope of program, basically. But the main idea is now the government focus on the human resource. Why? Because now Indonesia, in terms of the population age group, mostly we are on the productive, so we have more productive age group other than the non-productive. So it's the time, it is the actual time for Indonesia to excel, basically. And later on the later pillar with business climate and cybersecurity, also the research, innovation, and business development, funding and investment, and policy regulation. Because the time is very limited, so let me continue with the slide. So I just want to emphasize on this slide that if we combining the legal works with the technology, actually there is a lot of opportunity can be happening. So like for each of these legal service basically can be really automate and also improve in terms of the workflow with the technology aspect. And with this opportunity, basically, I want to give some more contextual example. Wait a second. So in Indonesia, we follow a civil law where the most of the law system is civil law, where it's mainly based on the regulation. And to give you some context, now Indonesia, from the highest tier of the regulation until the lowest one, which can be on the village level, there are more than 320,000 regulation. So basically, in Indonesia, every government institution have the capability to create a regulation. So that's why we have those kind of numbers of regulation. And not only we have that much, since I think it's very consistent from the past 3 years, we have more than 4,000 new regulation every year. And we also have a lot of hierarchy of the in of regulation. And like if you practicing law in Indonesia, or maybe you have some transaction in Indonesia, you need to take into account everything or from this kind of regulation. So eh, at Hukomonline, basically we have the largest knowledge base, legal knowledge base in Indonesia that we have been accumulated since 2000s. So we have the largest legal database in Indonesia and the legal analysis, the regulation analysis. So basically, we provide in AI, which we call it ILX, is something that we put on top of that knowledge base, and basically it's just like ChatGPT, where you can ask any specific question about regulation in Indonesia, and we will provide you answer which reference to our existing content. So it's not something that the AI can hallucinate the answer, but the Alex only answer from the given source material that has been created from us. So for example, in Indonesia, if we prompt list of regulation related to merger or acquisition of technology companies, then you can see there are several regulation on the right side, or there are around 6 of regulation, whether it's a government regulation with the from 1998, from merger, consolidation, and etc. And there's also about the law about the prohibition of monopolistic practice and unfair business competition, and several other hierarchies of the regulation. So like you can imagine if the in-house counsel or law firm, they do not have this kind of technology, means that they need to scavenging all of the related regulation and connecting each other of regulation, because as you know, regulation has so-called life cycle. So the regulation can be enacted and can be, for example, some of the article can be changed or amended, and maybe in a lot of case also the regulation has been changed. Like there is new regulation coming in and you reference the wrong regulation or the obsolete regulation. So we take into account all of the dynamics, and we can provide the relevant answer giving from the users. So in terms of the topic of this, also we ask about the specific on the obligation. So we can just continue the conversation with the Alex. So it can answer like this kind of prohibition of anti-competitive practice, the assessment of competitive impact. So like the it can provide a step by step on how to conduct the M&A in Indonesia. So we can also even asking a very technical question, like whether
Sorry, sir. You have
Yes.
just 2 minutes left in your slot. So thank you.
1 minute left. Okay.
No, 2 minutes. 2 minutes.
2 minutes. Okay. All right. So yeah, basically, if we ask about the term of the notification of M&A, we ask whether in Indonesia is it a pre-notification or post-notification in terms of if there is an M&A. The system, the AI can answer directly whether Indonesia is following the post-notification requirements. So basically, the transaction need to be legally effective, and then no later than 30 working days, we need to report to the authority, basically. So this kind of question really helps, like not only the legal counsel within the countries, but also maybe in from the international, because some of the transactions supposed to be cross-border. So we think like this kind of innovation can help improve the transaction of M&A. So and you can imagine like if conducting the M&A, there's a lot of things need to be due diligence, like the compliance of the company, whether it want to be acquired or being merger and etc. Yeah, basically it's just a way to understand exactly about what is the legal on different aspect in Indonesia. For example, like whether we ask about the data privacy and etc. So this is also one of our, I would like to present is from all of the discussion, I can say discussion with you with the Alex, you can generate a legal memo from those discussion, and you can produce this kind of text with very well formatted, and it can help you like catapult the process, your legal research, and then just put some more contextual on your research and continue with the transaction itself. Yeah, I think maybe for the last part of my keynote speech, what I would like to emphasize is in several countries that might have a follow like a civil law that might be really complicated, like in Indonesia, and maybe in some Asian country we focus on the civil law. In M&A, we need to see a lot on the regulation coming in. So like whether the compliance of each the company, and some in most cases the regulator is not only from one institution, it can be many. Like if you do in financial technology, you need to comply with the regulation from the authority of the finance, but also from the employment, you need to do other institution, and for the location of your business activity. For example, you are in some area in Java, then you need also comply with the local regulation as well. So basically, the technology really help us to like get sense of it, like how the regulation connecting each other. And I think this is the key element, the use of technology to improve the merger and acquisition to be more efficient. I think that's all for me, Valinda. Thank you.
Well, thank you very much for your opening remarks. The statistics in relation to the M&A trends in Indonesia and worldwide, the remarks on the big investments also from foreign companies and corporations in your jurisdiction, and your government's digital plan, and everything that you have explained about the super interesting AI system, Alex. So I think we will get back to you with at least one question afterwards. But
Sure.
now we will start the first of the two sessions introducing our two speakers, whom I have a pleasure to moderate today. The first speaker is Mr. Pedro Duarte Batista, who will be talking about the increasing importance of tech M&A operations, especially in Spain. And the second speaker is Bratara Damanik, who will be talking about the role of law, compliance and policy in shaping the digital economy. So let's get started with the introduction of Mr. Pedro Duarte Batista, who is an alumnus of the CCLS Queen Mary University of London with an LLM in Computer Communications Law, graduating in 2013. Pedro also holds a law degree and a master's degree from the Catholic University of Porto. He is a qualified lawyer and currently works at the Portuguese law firm Vieira de Almeida e Associados, one of Portugal's leading law firms. His role involves significant responsibilities in corporate and M&A transactions. Prior to joining VDA, the law firm, he has worked at Garrigues and at Deloitte Legal. Pedro is specialized in corporate and M&A laws, in which he has gained an extensive experience through his active involvement in numerous high-stake transactions, especially in the tech sector. His expertise includes advising on acquisition and sale of companies, corporate restructuring plans, and corporate assistance. Pedro has also been ranked in the best lawyers list for Portugal in 2024 and 2025 in corporate law. So congratulations. Pedro, the floor is yours.
Hello, good morning, or good evening, or good afternoon to all. I'm just trying to share my screen. Let me check if I can. I think it should be there now.
Almost there. We cannot see your screen, so maybe you should share it again. Now it's okay. Perfect. Thank you.
Okay, that's good. It's not okay. It should be good. Okay. So my presentation, I think it will be faster and smoother, I guess. So I'm speaking about today the importance of technology in M&A and the increasing importance of these kind of matters in the M&A global world. So in terms of as a general remarks, according to recent studies over the last decade, the technology sector has more than doubled its share of the global mergers and acquisitions market, meaning that 10 years ago, the number of transactions in this sector were really lower than it's today. For you to have an idea, and today, in Portugal last year, 70 deals were made of technology companies. And it was second highest market share, only below the real estate market, which is still on higher demand nowadays. However, as we will see, the specific characteristics of tech companies may create difficulties and additional difficulties in this sector, in this global market. But we will address these in a couple of minutes. On a different note, just for you to be aware of, the technology also plays a role, or an important role, in the conduction of the transaction itself. Today it's really common to have AI structures and AI software in order to conduct these operations, especially in due diligences. It's really seen, or it's been really used, a lot of software to conduct contract analysis, or to draft contractual clauses, and to assist in the review of documents. So the technology is also playing a role in the way that transactions are dealt with nowadays. On the second topic that I would like to give you an answer for, this is more a generic approach, is how to structure an M&A transaction. As we like to say, there are mainly 5 phases of transaction that when you are think about it. As this one, the first one is the previous assessment. I mean, it's when you reach to a company or to define a target company or of a technology you want to buy, or of a company that's profitable and it makes sense to have in your portfolio. And then a big group of companies decide, okay, let's acquire a company, and they do a prior assessment of this company. On the second moment, you will have the negotiation and the letter of intent, meaning when one of the parties communicate to the other that, okay, look, I want to buy this company, I want to be part of this company, so let's agree on the main terms for this transaction. And in the third moment, you will have like a due diligence moment. Due diligence is when you conduct technical, tax, legal, and technological assessment of the company or over its assets. In a tech company, it's when you really go and it's still on, because I think Valentin is frozen.
I'm sorry if my face is strange, but I'm still with you.
Okay,
yes, I can hear you clearly.
Okay, that's good. Okay.
Yeah,
So,
I will interrupt the video so you cannot see my strange faces, maybe.
no, it's not strange at all. Don't worry. It got frozen, and you are the only one that I'm seeing. So I was wondering whether the connection was still on. That's why I was just questioning. So, and in the third moment, you will have due diligence, is when you look into the company to go with the details of the company. You look into the contracts, you look into the tax liabilities, you look into the business, and it's when you decide or not to go or not with transaction. This is when you really go deep into the company to get to know it a little bit better. After that, you will have the negotiation and closing. And when we speak about negotiation, of course, is when you type all of those contracts that you will sign to have a transaction going on. I mean, the share purchase agreement, the shareholders agreement, when you decide on what is being acquired, what is out of scope, what is the liability of the sellers, what are those warranties that the sellers are giving you with regards to the company, to its technology, to its IP rights, and all of those stuff that will be important for a buyer when it's acquiring a company. And then you will have after the closing of the transaction, I mean, when the shares are really, or that company is really bought, you will have the post-closing integration that you will see will face additional difficulties. Giving you this heads up on the M&A transaction, we can now move to the particulars of the M&A in the tech sector. The first biggest difficulty in this M&A sector is that it's very complex to evaluate a technological company. As you are aware, sometimes, or depending on the moment in which a company is being acquired, sometimes these companies only have ideas, or only have, an idea of a business, or a business that is really just starting, no big contracts, no big customers. There is nothing relevant there, but as a purchaser or someone who's looking into this investment, they can see a little bit longer and a little bit further. So sometimes when we are speaking about random or common M&A markets, you will see that it's easier to define a value of the company, because if it's a company owning real estate, or a company with a common activity or a standard activity, you will look to the EBITDA, you will look to the value of these assets. anything that you can look to have, an economic perspective of the company. But sometimes in tech companies, you will not have that. You will only have a technology. So it's a matter of to evaluate that technology and to believe and what is the value that is behind the technology and what you can use that technology for economic perspective. A different thing or a different hurdle that may arise is related to the nature of of a lot of technological companies. As you know, a lot of tech companies start being a startup, and when you are a startup and you raise investment from different sources, you will end up having a complex cap table with founders, investors, pre-seed investors, seed investors, a lot of different rights attached to the shares. And when you are buying a company, you are dealing not only with the founders, but most of the times you are dealing with all of these investors, sometimes 10, 11, 20 investors. So it means that when you are completing a transaction, you are negotiating with all of them. And all of them have different knowledges about the company. The founders, of course, know about the business. The investors do not really know about the business. And they, of course, do not want to give you proper warranties over the business of the company. So it really creates difficulties in the negotiation of the contract. On top of that, or in addition to that, you are most of the times required to conduct a proper analysis of the IP of the target company. When I mean that you need to analyze the IP of the company, it's not only from a legal, but also from a technical perspective. I mean, you will need to check whether the IP, whether the technology of the company are indeed really protected, and there is a critical issue, and is in these M&A deals is when sometimes you will need to check or conduct freedoms to operate, or you will need to check whether the rights of the company or whether the technology of the company conflict with any other patents or IP rights that may exist in different jurisdictions. That's when you need to ask technical people to get involved and to conduct that analysis for you. And sometimes it takes a little bit longer, and you cannot just rely on the warranties of the sellers. You need to, as a buyer, to really become aware of where you are putting your hands on. Another thing that you need to carry or you need to work is the involvement of the founders in the future of the company. Although tech companies always have, proper technology and sometimes have some certain IP rights, a lot of times, most of the times, it's all inside the head of the founders. Much more than the technology, what you want to have is the involvement of the founders, because they know the product, they know the technology, they know the path they want to follow. So you really need to take care of the involvement of the founders in the future of the company. You will need to convince them to stay with you for a couple of time. You will need to have their involvement, to giving them equity in the company, so that they want to make sure that the company, if the company grows, they can still grow. And lastly, you will follow a lot of integration challenges and cultural differences. You will, if you are buying a technological company, you will notice that you will probably need to be aware of the integration of the systems. I mean, if you have different software operating, you will need to make sure that both softwares can be integrated. And of course, if you are a tech company acquiring a different tech company, you will have different teams working with different cultures, and it's very common for a company, let's say from Indonesia, to buy a tech company in Portugal or the other way around. And of course, there are different cultural backgrounds, and sometimes it's just hard to make sure that those cultural differences can work together. So this was my presentation. I opened for the Q&A, and I'm not sure if you are going to do the Q&A now.
No, we will await the next speaker's presentation, but I thank you very much because you provided very useful insight on the importance of technology in tech M&A operations, and I appreciated very much your remarks, as I do, and I've done IT and data protection due diligence, the importance and interplay between asset evaluation, IP rights, control of the IP rights, and the fact that M&A lawyers and operators must be people persons and coders and work all together. So thank you very much for your presentation. And now it's time of Bertara Damanix, who is an alumnus of CCLS of the QM Mary University of London, having an LLM in International Business Law, graduated in 2017, and as an Indonesian qualified lawyer, he works at HHP law firm based in Jakarta. Their role involves handling complex corporate and M&A transactions in the telecommunication and technology sectors, including share and asset purchase transactions within the tech industry. Bratara also advises local and offshore tech companies in various fields such as e-commerce, cloud computing, gaming, AI, and data protection, focusing on helping clients navigate legal requirements and identifying practical measures for operating in Indonesia. Bratara, the floor is yours. Please go ahead and remind that you have 15 minutes. Thank you very much.
Thank you, Valentina. So let me share my screen. Can everyone see it?
Yeah.
Yeah. So hi everyone. So I think now I'm gonna talk about M&A in Indonesia. So I guess Mas Arka from Hukomonline has already provided like detailed explanations on the trend in Indonesia. So what I'm gonna provide is more toward how M&A works in Indonesia normally, and what is the key challenges. So a brief overview of M&A Indonesia. So maybe Pedro has already provided as well. I think it's quite similar in every jurisdictions, including Indonesia, but I'm gonna share you some insight on this. So in terms of M&A, there is what we call normal M&A or traditional M&A. It can be a shares acquisition or assets acquisitions. Share acquisitions is when you purchase a company by way of acquiring shares and trigger change of control. And asset acquisitions by way of purchasing a business. There are characteristics, depends on how do you want to structure the transactions. And there's also a growth M&A. What I call a growth M&A is referring to a startup funding, meaning that as you may already be aware, and in terms of startup, there are various seed series funding or series A, series B funding. So those type of M&A, we call it a growth M&A. There's a difference between a growth M&A and normal M&A. I think Pedro also already touched it a little bit, but in a growth M&A, as you may already know, there are a lot of large group divers of investors, like of venture capitals. It may be 10 or more shareholders, investors, but in a normal, typical M&A, maybe they only involve 1 or 2 buyers. And in a growth M&A, normally founders will want to have control over the operation of the company. So shareholders or investors more likely to want to have like control over certain actions, but they do not want to involve directly in operation of the company. It differs when in the normal M&A where the shareholder who have the majority shareholding ownership wants to have like a member of director, wants to have control over the operation of the company. There are various classes of shares in a growth M&A. Compared to normal M&A, it may only have 1 class of shares. So there are differences between normal M&A and growth M&A. The process itself is quite similar in every jurisdictions. We have due diligence. We also negotiate transaction document. Normally we have SPA. We also have subscription agreement and shareholders agreement. Normally in a share acquisition, we will have SPA and SHA. I think this is the detailed typical M&A transactions in Indonesia. So the parties can sign confidentiality letter to ensure it stays confidential. The parties will also negotiate a letter of intent or term sheet. The purpose of this is to ensure that the parties have like agreement on the key issues or key points such as purchase price, maybe adjustment, or maybe other things such as what kind of structure of the transaction that will be conducted. So these key points will be agreed in advance, and then after that, the parties will draft the transaction documents, more detailed documentations on the transactions. Typically, it will involve SPA and SHA. In practice, the draft of these documents will provide by sellers because most of the time, seller or the tech company itself has their own preference, and it's easier and it's more effective to have a seller the draft to provide the first draft. And then we also have due diligence. I think similar to other jurisdictions, you have legal, tax, finance due diligence, and then you have negotiation meetings, you assign transaction documents, and then after from the due diligence itself, you will identify any CPs, any indemnities that need to be input in the transaction documents. Other than that, I think it's quite similar to other. There's a completions and post-completion as well, including integration. So on legal framework, I think it's interesting because as you may see from Mas Arka states that there are various regulations in Indonesia, thousands of regulations in Indonesia. But at the moment, there is no specific comprehensive tech-related M&A regulation in Indonesia. So normally the general regulations such as company law will also affect tech transactions. So in terms of M&A in tech sector, we still need to monitor other regulations such as company law, data protection law, telecommunication law, and electronic system operator regulation, and foreign investment rule. I'm going to touch it later on a bit. So key challenges. So in terms of M&A in Indonesia, particularly in tech sector, normally we want to have an efficient tech transactions. But unfortunately, as I said, there's no specific tech sector regulation for M&A in Indonesia. So all tech sector transaction is still subject to the general transaction under company law. And acquisition process in Indonesia takes some time. So you cannot have like there's an issue. Normally, I found it in a foreign investment transaction. So offshore companies normally want to have like an efficient transactions. Sometimes I've received a request to have like when you sign the SPA, you want to also close on the same date or maybe on the next day. But unfortunately, in Indonesia, there are some process that need to be taken as required under the company law. So in terms of, for instance, in terms of acquisition, there's a requirement to issue a notice, one newspaper announcement and employees announcement, 30 days prior to a closing. So you cannot have a signing and a closing on the same day. So when you sign an SPA, you need to you need to conduct a newspaper announcement first. And then after 30 days, you will then can complete or close the deal. Basically, the effective of the self-transfer will need to be conducted after 30 days. So, and there's a challenge as well on share acquisitions, must be signed before a notary, because most of the time, offshore companies normally sign electronically, but in Indonesia, share acquisition must be signed before a notary. Okay. Next one is foreign investment rules. I think in Indonesia, several business sectors are closed and open with certain restrictions. But most of the tech sector like cloud, e-commerce, AI is open for foreign investment with certain conditions. But for telecommunication, it's more highly regulated. So business or investors need to understand the regulatory landscape first, because there are business lines that are closed for foreign investment or open with certain restrictions. And in Indonesia, foreign investment must have a minimum paid up capital around USD 600,000 or IDR 10 billion. And in practice, in terms of licensing, if we're talking about a new investor coming up from offshore and then acquiring a local domestic company, so basically the local domestic company will need to be converted to a foreign investment company, or what we call in Indonesia is PMA company. So in terms of this conversion, there may need to be an update of license, and this may take process after the closing. Other key challenges, I think, on data protections, tech companies is identical with processing personal data. So we have seen a lot of e-commerce platform or any software as a service platform. Those type of companies process personal data. And we have a law, a PDP law, Personal Data Protection Law in Indonesia. However, the PDP law is still only provide a regulatory framework. More detailed elaboration has not been provided yet. I understand the government is still discussing on the implementing regulations, but the challenge on data protection is more toward operators or platform operators are still sometimes confused or still monitoring on what is the authority expectation on how to implement the data privacy requirements. But in terms of data protections, what I want to emphasize is that a platform operator need to obtain like a lawful basis. This is the most key integral part. So lawful basis of processing personal data is one of the important part, whether it's a consent or whether it's a contractual arrangement with the customer. So those type of lawful basis need to be obtained. Although we have like a DPO requirement, data protection officer requirement, or data protection impact assessment, this type of requirement is still evolving because we are still waiting for further implementing regulations. Merger control. So in Indonesia, including tech companies, we also subject to a post-transaction notification to a competition authority. So in terms of post-transaction notification, not all of transactions will subject to these notifications. There are thresholds. Once you pass the threshold, you will then need to submit the post-transaction notifications. However, it may take time to determine whether you are subject to the post-transaction notifications. So in practice, we conduct like pre-closing voluntary consultations with the authority, with the competition authority, to understand whether after conducting the M&A, after completing the transactions, will we be subject to the post-transaction notification?
Sir, 4 minutes left.
Yeah. On IP, so IP, I think Indonesia, from my experience, IP registration is quite a lengthy process in Indonesia. So we're gonna need to check whether whether the tech company registered its IP. Whether it's registered under the name of the company, or maybe on the founder or employee, or even not registered, like I say. And even in an asset acquisitions, when you acquire a software or when you acquire a business, you need to conduct your own IP registrations, or maybe you need to transfer the existing transfer IP from the existing owner to the acquirer, to the purchaser. IP is a lengthy process, so it may take time for new transfer for registrations, months. So I think investors need to consider these issues when it comes to intellectual property. Employment. Indonesian tech companies as well, employment is an essential part because when it comes to employment, a purchaser or acquirer does not have the right to terminate employee due to the M&A transactions. So they need to maintain the employees. And from my experience, offshore companies normally has a different type of terms in employment, and then they want to implement these terms into the employment contract in Indonesia. But bear in mind that if these terms are detrimental to the employees, it may trigger the employee's right to terminate. And it will lead the payment of compensation package or severance package. So it is important to have a good discussion and good management skills on managing employees' expectation. And then when it comes to asset acquisition, unfortunately, Indonesia do not have like automatic transfer of employment in an asset acquisition. So basically, employees must agree if they want to be transferred to a new company. It's because we do not have like automatic transfer of employment in an asset acquisition. So in terms of recommendations, like I said, tech companies are front runners. They push boundaries of technology, but also regulatory framework. Like I said, at the moment, there is no like specific regulatory framework on cloud or AI. So what we do is we implement practical approach to manage expectation of the authority. So the due diligence on these companies, these tech companies, are not always easy because they always push the boundaries. They want to evolve. They may not be like take an approach like very compliant approach on regulatory because they want to evolve. They want to push their business of technology. So I think if a foreign investors want to require them to comply with the letter of the law, it might commercially be counterproductive because, like I said, the letter of the law may not support their business as well. So they need to find another approach, another practical approach to operate. That's why it's good to have a relationship with regulators because dialogue with regulators is important. Normally, we suggest investor to understand the landscape of the regulation in Indonesia and understand the risk, and as much as possible, we encourage investors to mitigate any risk from by implementing an indemnity or warranties or any CPs in the transaction documents because, like I said, these companies is always front runners and pushing the boundaries of regulatory framework as well. I think that's from me, Valentina. So I
That's
give the floor to you.
Thank you very much for your really comprehensive overview of the structure that an M&A operation may have in general, but specifically in Indonesia. And I especially appreciate the differentiation between the various challenges that can be encountered in those operations, as well as these last practical tips, which I think could be extremely useful for prospective investors in your jurisdictions. So what can we say? We had two amazing speakers having provided very comprehensive and thorough overview of the legal compliance and the practical issues in tech M&A operations. So now we can open the Q&A session, and we invite the audience to write the Q&As, the questions more than answers, the questions in the box below on Zoom, if you have any. So yes, there's a, well, thank you very much, Isal. The question is for Mr. Arca, the CEO of Hukomonline, about how does Indonesia's legal framework influence M&A transactions, and why is it important for students studying law or finance to understand these regulations, on the premise is that Israel is at her final or is, no, sorry, at his final year student from National University. So Mr. Arca? Yeah. Should I repeat the question?
No, I can read it from the chat. Thank you, Vanina. So
thank you.
Thank you, Isal, for the question. So basically, the whole overall legal framework in Indonesia, as also mentioned with Barata, it's comprised of several law, whether it's from the data privacy, is this on the limited or the Undang-Undang PT limited law, and then also several about the competition law as well. So basically, as the following the regulation in Indonesia, basically in every transaction on every acquisition, more specifically, it need to ensure that it's comply with the whole obligation that can get out from the regulation itself. So so basically, it is important, and not only for a legal person per se, but also for the business people to understand the whole end-to-end process. And also in my experience, basically, as mentioned earlier, my background is in computer science. However, it is necessary for me as well whenever if there is a new acquisition and our strategy that happening with the company, then we need to consult it with the legal team and also with the external counsel. But as also Barata mentioned, in most cases that we also cover in our news at Hukomonline, somehow the transaction happening in the technology sector might be new, is something that has no precedent at all. So it can being a lot of it require a lot of discussion and just convincing the regulation itself whether the gray area that been happen on the transaction can hold the transaction overall. I think that's my answer on that, Valentina.
Thank you very much to both. Then I will read Evelyn Julian's question. The question is directed to Mr. Sorry, the chat is crazy, is going crazy. To Mr. Bara Damanik. So I will read the first one because then I will pass another question on to Pedro. What is the impact of IP ownership by founders or employees on company valuation in M&A operations? And can this be a barrier to negotiation? If IP is not registered before the M&A process, is it still possible to claim or protect it? What are the risk mitigation strategies? Basically, have you understood the question? How dealing with IP role in tech M&A operations, whether they are registered or not, and what the importance and the relevance of their ownership, whether belonging to the target company or people working for it?
Yeah, thank you, Valentina. So thank you, Evelyn, for your questions. So when it comes to IP and in the tech sector, I think it's so essential. IP is so essential for tech sector. For instance, because the main operations of a tech company is solely lie on operation of tech or operation of system or software. So all of this system, all of this software has an IP. So basically, when it comes to IP ownership, it is important and it will affect the valuation itself. So This may be to become a barrier to negotiation if the IP is owned by other party or maybe other founder. It is not owned by the company. It will affect obviously. And can we still protect it? I think in terms of IP, we can always put it in the transaction document. For instance, if the IP is registered under a founder, we want to have it to be transferred to a company, of course, because we invest in the company, not invest in the founders. So that things we need to negotiate with the founders to transfer the IP to the company, and then this can be put in the transaction document. We can always say that we will only close the deal, we will only transfer the price, the purchase price after we close the transfer of the IP. So these kind of things, or maybe we can also ask indemnity from the founder saying that all of the IP of the software of the system will be, if there's any claim in the future from any third party, the founders will indemnify the investor. So something like that can always be implemented in the transaction documents to protect ourselves in the M&A process. Yeah.
Thank you for the answer. Now I will give precedence to the question placed by Jonathan only because it's strictly directed to Pedro. Pedro hasn't had yet the opportunity to answer a question. Then I will go back to Andalan's question, because thank you guys for your engagement. It's crazy and it's great to have all those questions in the chat. So Jonathan's asking to Pedro if there are any specific differences in the tech M&A proceedings or challenges in Portugal as compared to the challenges and the specificities of M&A's proceedings in Indonesia. So what are the main risks, the main challenges that you have encountered in your profession?
I would say, and from the presentation from Mr. Bradara, I would say that we have the same, the same difficulties and the same worries when conducting an M&A transaction like this. Even if it's an M&A transaction or if it's an asset transaction, we always follow the same difficulties. I think the biggest difference here in Portugal is, I think we don't usually need to wait between signing and closing for any particular of tech sector. I mean, I've done transactions in the tech sector which have a simultaneous signing and closing. It happens on the same date, and it's possible. I would say that sometimes we would need to check, or we need to wait. It may happen for the competition law authorities' approval, and that may create an additional difficulty. But again, that is a different topic, and because of one aspect, these tech sectors are so different, and the activities are so different that sometimes it's difficult for us to find the relevant market and to find out whether or not a transaction must be noticed to antitrust authorities. But I would say that generally speaking, the difficulties are pretty much the same.
So thank you very much. We are going to ask Andalan's question. Andalan is from Jakarta, and the question is directed to both Pedro and Batara, so you can decide who is going to answer. The question is, when talking about M&A in technology companies, the nature of fast-growing trends and market volume, also valuation, reminds me of a hostile takeover mechanism. Is it common in tech M&A, or actually a bad approach for the business environment? This is for Pedro. And for Batara is, especially in Indonesian context, is there any legal frameworks preventing promoting said hostile takeover mechanisms?
Okay, let me just tell you something with regards to that. in Portugal there is no common public hostile takeover available. The only way you have an hostile takeover happens when you negotiate that on a shareholders agreement. I mean, when you put yourself giving a call option to another shareholder, or sometimes when you have when a company owns more than 90% of the shares of the other company. After such acquisition of 90%, it has a period of time of 6 months in which it can conduct an hostile takeover and acquire the shares of the minority shareholders. Those situations happen, but most of the times with regards to minority shareholders who have just lost interest in the company and who have, run away from their duties as shareholders and do not participate in general meetings and so on. It's not very common to have this hostile acquisition in an M&A transaction in the tech sector, because these are recent companies, all the founders and shareholders are involved, and all of these matters are regulated in the shareholders agreement. So I wouldn't say that you don't face that risk, or you don't face an higher risk in a tech company than you would say face in a normal company. I would say that.
Yeah, I think to add.
Yeah, okay.
Yeah. Thank you, Vandana. I think to add to Pedro, I think in Indonesia, when it comes to tech sectors, as you have mentioned, there are shareholders agreements in every series funding. So those kind of shareholders agreement also subject to a reserve matter, which when it comes to selling shares directly from shareholders to another investor, they have like a certain requirement in the shareholders agreement. So on top of that, in our under Indonesian company law itself, when it comes to acquisition, when it comes to acquiring a new company, triggering change of control, our company law require the Acquisition Act to be approved by the majority of shareholders. So basically, these basically in practice, it's rarely happen in a tech sector for hostile takeover because they are being protected with these provisions. Andalan, yeah.
Thank you, Bratara. I think that we can close this Q&A session of the first panel, and I thank the panelists and the audience for both engagement and insights. Now, I gladly pass the moderator baton to Mr. Zheng Yun, who will be moderating the second panel of the speakers. But before that, I would like to introduce him by saying that Zheng is an alumnus of the CCLS Queen Mary University of London with an LLM in Comparative and International Dispute Resolutions, graduating in 2013. Currently, Zheng is the legal counsel at Shopee LLC. Apologies if I haven't pronounced it correctly, and that is an e-commerce platform in Vietnam. He supervises all legal matters of the firm for compliance in the Vietnam market. Zheng is also a visiting lecturer at Ho Chi Minh City University of Law, and before working for Shopee and Law Uni, Zheng worked for Baker McKenzie, as I did, and Allianz and Linklaters law firms. Zhen's specialization includes investment law, e-commerce law, commercial law, and many other law areas. So I thank you all, organizers, speakers, audience, for this event. It's been great. It's been a blast, and I will see the recording. Now I have unfortunately to leave, to disconnect for further contingency. So thank you very much. Zheng, the floor is yours. Bye-bye.
Okay, thanks for the kind introduction, Valentina. Good morning, good afternoon, good evening. Selamat malam. It means good evening in Indonesian language. Magandang gabi, good evening in Philippines, Tagalog language. I hope that I'm pronouncing correctly. So, in this second session, there will be 3 speakers who will do their presentation separately. First, and then followed by a Q&A session before the whole session is concluded by me, and later and closed permanently by me as well. So let's start with the speaker. Number one, Mr. Miguel Di Mayake is an alumnus of Queen Mary University of London with an LLM in technology, media, and telecommunications law, graduating in 2023. He is also a technology, media, telecommunication lawyer qualified in the Philippines and London, Wales. He has broad experience in advising legal and regulatory requirements in identifying legal risks in the field of telecommunication, data protection, AI, fintech, and cross-border online transaction. That's my brief introduction about the first speaker. Now the floor is yours, Miguel.
Thank you so much for that kind introduction, Zhang. Let me just pull up my slides. I hope everybody can see the slides.
Yes, I can see it now.
Okay, thank you very much. Okay, so my presentation will be about how the Philippines is as an M&A market and in the broader realm of the digital economy. So for starters, because this presentation will be very general. So if you feel that it's too general, if you have specific conditions, specific insights, or specific peculiarities, I do suggest you have to consult your legal advisor, because what will be discussed here are only purely generalities. So let's now talk about how the tech M&A is in the Philippines. Uh, Fortunately or unfortunately, where depending on where your perspective is, the tech sector M&A is not that fast moving in the Philippines. Um, in the last 5 to 10 years, there are only two big ticket mergers or acquisitions in the Philippine tech sector. One is when Grab bought out Uber a couple of years back, and then when and Financial, Alibaba's subsidiary, invested hundreds of millions of dollars with Globe Telecom, who is the operator of a fintech firm here called Gcash. So apart from that, there are no more publicly known mergers or acquisitions in the tech space. There could be more out there that's not publicly disclosed because of deal concerns, confidentiality concerns, or they were not notifiable. There is that they are not a notifiable transaction with the Philippine Competition Commission. But uh, this at this time, only these two transactions are the big ticket names. Now, if you are thinking about moving into the Philippines, whether acquiring an entity or investing in the Philippines has been like very active in like making it a more attractive investment destination. Um, the previous president signed a law to lower the income taxes of corporations from 30 to 25, and they have streamlined all income tax holidays, perks, advantages, or privileges that qualified transactions, qualified companies, qualified investments may have in the Philippines. Previously, they have to talk to about 10, 15 government agencies. Now, they only have to talk to one. So that streamlines things. But apart from tax, the government policy in the Philippines for M&A in general, it's very neutral. They don't really support M&A. They're not really anti-M&A. They're not really looking into supporting companies to be bought out, or they're protecting companies that will be bought out. So if you want to do M&A, that's fine, but the government will not really support you. They will approve your transaction if it's qualified, but to say that there's an overarching policy that M&A is encouraged, even there's nothing like that. Unfortunately, because of the Grab Uber deal, M&A in the M&As in the tech sector is not does not have a very good public image. When Uber was taken over by Grab, there were very negative perception with the public, like Grab is monopolizing this, Grab is doing this, Grab is doing that. It's left and right. Everybody was saying that Grab is the king, and we're all at grab's behest. That may be the public perception, but um, it is what it is. But if someone is a member of a commuting public, and then most likely that's the opinion. But from our government side, all they can do from that perspective is try to rein in this power of the so-called monopolist. But it's a question of like how far can the quote unquote monopolist push the boundaries. But if you're thinking about foreign M&A on another side of things, or like if you want to pour in money, you look at, if, let's say for example you're a PE entity, for example, and you found a sprawling company in the Philippines want to put money in. Generally, the framework is open, but only you have to take note of the foreign equity restrictions. Previously, the list is a lot longer, but they signed a law a couple of years ago that practically shortened the list. And out of the list, these are the only key things for a tech company. If the tech company is engaged in mass media, I'm sorry, foreign ownership, foreign money is not allowed. If the tech company is engaged in advertising, only 30% can be owned by foreigners. But if the tech company owns land, that company can only have a 40% ownership of foreigners. Now you might ask, what's mass media under Philippine law? What's advertising under Philippine law? Unfortunately, there is no singular definition of what mass media is, of what advertising is, but there are scattered definitions across a lot of laws in the Philippines. For example, the law on tobacco regulation has a definition of advertising and mass media. The law on elections has a definition of mass media and advertising. And if you look at it, the definitions are a bit converging on a certain point, but diverging on others. So the safest bet, if you want to know if it's mass media advertising, go talk to a lawyer. Now, this is the merger notification regime for the Philippines. Um, under Philippine law, the Philippine Competition Act, if you breach these thresholds as shown on your screen, which were last updated last year of the 1st of March, before you sign the definitive transactional documents, it could be your share purchase agreement, it could be whatever, as long as you feel that it's the definitive transaction document, you have to notify the Philippine Competition Commission. The Philippine Competition Commission is fairly fast, as they say, in reviewing acquisitions or mergers which have a size of transaction that reaches around $55 million, or the size of party being $134 million. Now, the problem is if the Philippine Competition Commission has some reservations, it will notify the parties and say, we might recommend your transaction to be reviewed under the so-called phase two review, which is a more in-depth analysis of the transaction from a competition perspective. Typically, the PCC will request for more information, more economic data, more market research, more of this, more of that. So your transaction might become more expensive in that regard. But other than that, the PCC will most likely greenlight your transaction apart from certain industries where there are like a few players. Now, let's now go to data protection. The Philippines has a data protection law, the Data Privacy Act. It was enacted like 10 years ago, or more than 10 years ago. Um, Unfortunately, the data protection law in the Philippines and its regulator does not have a clear guidance of what happens if there is a tech M&A. What happens to the personal data that the company has? What happens? Do you need to obtain consent again? Do you need to do this again? Whatever. So my advice is go look at all the documentation. Go look at all the consent forms, privacy policies. If you ever have conducted privacy impact assessments, look for those. If there are subcontractors or data processors, look for those documentations as well. And if the target company is handling data transfers for other countries like Philippines to wherever, you have to look at the documentation there as well, because similar to other jurisdictions out there, the Philippines has a regime for data transfers in that it requires an equivalent level of a comparable level of protection similar to that of the Philippines. So the bottom line is we have to take a look at every documentation where that is for data protection. However, I'd like to point out that if the target company has a data lake or a data silo or whatever you want to call it, the transaction can be a bit murkier because we have to really dig deep what's in that data lake, what's in that data silo, what's on those hard drives, what's on in all of those servers that they have, because we have issues like, is that personal data, is that synthetic data, was that anonymized, was there complete anonymizations, those sorts of things. And that can mean additional costs. You might, as transaction counsel, you might need to advise the businessman that they have to hire computer forensic experts, they have to have programmers or things like that, just to determine if that thing is compliant with the data protection law. However, that is just tempered with the risk appetite of whoever is signing the transaction documents. If they're okay with not knowing what's in the data lake and they're fully aware of it, I think that's fine. But if they are little bit unsure, they might consider looking into it. But how deep they want to look at it, it's up to them. Now, IP. We've talked about IP during the first session. Similar to the other jurisdictions before, IP issues in the Philippines are the same. You have to look at the registration. Who is it? Under whose name is the registration? Is it in the founder, in the company, the employee, the contractor, or whatever? The good thing is, under Philippine law, the market practice is under any contractor agreement, employee agreement, or whatever that is, there is already an IP clause. And typically, the IP clause says any IP that you create in the course of this engagement, whether that's employment, contractual, or whatever, shall automatically be assigned to the company. It should be registered in the company's name. That's under your employment or contractor's agreement. However, if that thing does not exist, then you have to really know your law. Like, for example, in this particular case, the trademark is the patent I mean is should be in the name of the employee or the employer or the founder or things like that. I do have to point out, however, unfortunately, under Philippine law, software is not patentable. Software per se is not patentable. However, there are ways, according to my friends who are patent lawyers, there are ways to go around that, and they can creatively draft a patent claim that is patentable. But I do not know the specifics, unfortunately. But there is a way to patent computer-aided inventions, but not software. So, uh, if you ask me what's the difference is computer-aided invention is tries to evade the legal definition of a software, which is a computer program. So they inject things like what's the problem that's being solved, those things like that. And going further to the discussion, you have to look at portfolio management. Very important. Is the trademark valid? Is the trademark being used properly? Is the trademark being diluted? Is the trademark is the claim for the trademark a generic term, a descriptive term, a random term? Was are is the company policing trademark usage? Is the company policing patent usage? Are they enforcing licensing agreements and things like that? Those are the key points in under Philippine law for IP. However, sad to say, because there is a lack of activity in the tech sector as of the moment, unfortunately,
So you have
I
3 minutes left.
yep. Okay, thank you, Zeng. For IP, it's at the bottom of the food chain in in priorities. For employment, also paperwork. Paperwork. Check your collective bargaining agreements, because in some collective bargaining agreements, They have an opt-out clause if the company is going to be bought out or taken over, things like that. You also have to take a look under labor law if they're compliant with all labor standards, labor disputes. Check if they have been declarations of strikes and lockouts in the past and in the present. That could be a red flag if there's labor stability or union, or if there are grievances between union and management. And I think, and I have seen quite a few transactions that may have teetered over the edge had their labor disputes have gone too far. Now, let's now go to everybody's dreaded field, tax. Tax, tax, tax. The Philippine Bureau of Internal Revenue has somewhat been aggressive lately in enforcing tax obligations. So, for M&A, because tax liability is sometimes a red flag for some businessmen, we have to check, are they paying their taxes on time? Do they have their documentation on file? Do they have any deficiencies? Have they been prosecuted for tax evasion or whatever? Have they been subject to an audit by the tax authority? Have they been doing regular things, or have they been engaging in rather gray area tax management schemes, if you know what I'm saying? So it all boils down again to documentation. Now, let me just take a brief detour, and there's also another side of this tax presentation. For the M&A, there is a certain regime under Philippine law wherein taxes may be deferred, meaning not paid at the time of the closing of the M&A, but after. If the transaction qualifies under the so-called tax-free exchange regime, where the control of the company is transferred from one entity to the another, that could be the taxes on that transaction could be deferred if they meet the checkbox list of requirements. And that's for taxes. Now, how can we improve? What's next? Unfortunately, because the tech M&A scene is very much inactive lately, I don't know the answer to this, unfortunately. I have to be honest. But what I can see is an opportunity for the regulators, for the government, and for councils, transaction councils, legal councils, tax councils, advisors, whatever, to shape how tech M&A goes into the Philippines, because there is essentially, you're the trailblazer. You have the opportunity, we have the opportunity to make sure that the M&A functions as it is. So what I think should be done is, number one, the regulators have to be open, the regulators have to be clear, and the regulators have to be cooperative in dealing with transaction advisors and not interpret the law too restrictively or too narrowly or however they want to do it. Because, as probably in the case in other jurisdictions, the M&A laws here are crafted in general terms. It's not specifically to the tech sector, but given that there is still there's clearly lack of precedence here. So, with the cooperation of the regulators and the advisors, then there could be a situation where an M&A environment for the tech sector that is legally sound, but is also reflective of the underlying business realities of the transaction. Because at the end of the day, an M&A is purely a business transaction. And what do businessmen think? Unfortunately or fortunately, it's how can they improve their bottom line. If the M&A goes so expensive, nobody will do M&A.
Okay, 1 minute for you to summarize. Thank you.
And then, just one last point, Zeng. Under Philippine law, I still have not seen a tech M&A that has been turned down with the Philippine Competition Commission so far. And they have released policy papers left and right. And so far, the indicators are quite good. And so with that, and my presentation. Thank you.
Okay, thank you, Miguel, and especially for your sharing on the case study of Uber and Grab, because it has a similar nature in Vietnam as well. So now we move to the second speaker, which is Ina Polikakova. who got an LLM degree from Queen Mary University of London. She is a UK qualified solicitor, SRAIT 666944, and Ukraine qualified advocate, certificate number 000642. Ms. Ina is a lawyer with over 12 years post-qualification experience of advising clients on IP&T, corporate, commercial, and tax legal issues within top-tier law firms such as DLA Piper, Dentons, SVN Partners. She was also working as a senior legal expert to the EU delegation for Ukraine. That's my brief introduction about the second speaker. Now the floor is yours, and you will have 13 minutes for your sharing. Thank you and welcome, Ina.
Hi, everyone. Thank you. First of all, can you confirm that you can see my screen right now?
Yes, I can see your screen clearly.
Yeah, just like let me start sharing it this way, right? So probably you right now can see like in proper mode. Yeah. So
yes,
let me start. So today we will examine the M&A in the UK in the context of technology sector. So let's start with numbers. 1 second. Yeah. Okay. So as we can see, the numbers tells a compelling story, let's say. So in 2023, huge amount of M&A deals in tech sector with approximately $350 billion pounds. So unlike with the UK playing a pivotal role as European leading tech hub, in fact, UK costs 40% of Europe tech unicorns, demonstrating our strong position as a major player in the global ecosystem. And as you can see, the UK tech M&A market reached 31.1 billion in 2023, representing 33% of European tech investments. And the main focus, obviously, it was fintech previously and cybersecurity. Right now, AI is leading change. So we see like kind of like a huge impact on innovation and economic growth from that area. So generally about process, as probably you heard from the previous speakers and similar other jurisdictions, we have pretty much straightforward process. Let me walk you through how M&A actually works in the UK. We have a robust regulatory framework overseen by 3 key regulatory bodies when that's applicable. In respect of competition, we have Competition and Markets Authority. Then we have FCA if M&A concerns any kind of financial aspect of the deal and any kind of financial regulated authority. And we have the takeover panel, again, when that's applicable, and we will discuss that a bit later. And general process overview, so like 5 stages: initial approach and feasibility, initial negotiations, then due diligence and valuation. And basically like due diligence is the part where lawyers take part and participate. Then deal structuring, obviously very legal, but not only. It includes financial aspect as well, and then regulatory clearances and implementation. And implementation, as you know, will take a long period of time. So timeline consideration generally still between 3 and 6 months average, but can be longer depending on like kind of deal, what kind of companies involved, etc. Yeah, typically 6 months, I would say, if you're dealing with a huge deal. So in respect of legal framework, so basically, again, like Companies Act regulates, but UK common law jurisdiction, as you know, so it regulates to the extent it's possible to regulate in the common law jurisdiction. Then we have Enterprise Act 2002, again, like very limited competition aspects. And sometimes it's applicable with security screening, but like, again, like very limited given that kind of specific legal entity. Then we have secondary requirements, and they are like soft law, they are not law. So we have like city code on takeovers, we have listed rules, but again, if they are applicable, if M&A concern listed public companies. And then we have like some applications based on Digital Markets Act for tech sector. And we have specific, sector-specific, again, with FCA requirements. We have numerous requirements from FCA if we are dealing with fintech company and if we are dealing with regulated authority. And some guidelines on data-heavy acquisitions, but again, like that's kind of like rather guidelines and soft law. So that's why, like, mainly it's kind of like classic common law approach, I would say. So let's talk through some particular points in more details. Let's talk about challenges. Some of them UK specific, some of them coincide with like what previous speakers mentioned. So UK specific post-Brexit regulatory alignment. Some EU legislation still exists and still operates, some not. That's why like it's kind of task to check what is right now and how that's regulated. So apart from post-Brexit point, we have some points related to employment, and I will speak about them a bit later. But we have like data-related issues because we obviously have UK GDPR, so it's retained clauses from GDPR. Apart from that, we have our own regulations, meaning that we should double check whatever we are doing with data to comply with all the regulations around. Then UK has more stringent national security reviews and basically cross-border data flows with European Union. Then again, if it concerns, then that should be checked as well. Then like technical challenges, they are like depends on like technology, legacy system compatibility, cybersecurity, standardization. It depends like what kind of M&A we have, because sometimes it's very technical and it means that like technical aspects will be considered. Some of them are pretty much straightforward depending on the context. Let's carry on with challenges because we have a bit more. Yeah, so we have like some notification requirements. Again, like it's kind of new area, AI, quantum technologies and computing hardware. So that's why like we should all the time check what's going on in that respect. Then we have additional data infrastructure key controls. So we have 30 days initial review period if it's a massive data infrastructure deal. Apart from that, we have calling power up to 5 years. And we have some examples, like I listed them here, like when a particular M&A has been regulated heavily. So NVIDIA, it was blocked, and Newport, it was heavily regulated, again, like due to some particular issues related to data infrastructure, related to notifications, and given that it's kind of huge deal in the UK market, if you're talking about UK. So basically, like, but what I should mention and what I wanted to mention that like main points. So when you are dealing with the UK, you should remember about UK GDPR compliance, although we are not part of Europe anymore after Brexit. Then you should remember about cybersecurity considerations because they extend beyond compliance with NIS regulations. So again, like to compare with Europe, in Europe you have NIS regulations, here you have NIS plus local regulations. And then we need to evaluate security framework integration, incident response planning, increasingly important supply chains security. And like third point, like system compatibility assessment and all technical aspects you should take into account when dealing with documents for tech M&A in the UK. And like some additional points to consider. Next slide. Just give me a second to flip. Yeah, critical issues. So
5 minutes left.
yeah, okay, sure. So I will go. Yeah, so some critical issues. Let's start with competition considerations. So like market share analysis, although it should be taken not by lawyers, it should be taken by like who is in charge of commercial part of the deal, but we should take care of that as well from the legal perspective. Innovation market impact should be assessed. And then network effects assessment should be run. Then like patent portfolio evaluation, software licenses audit, open source compliance if we are dealing with particular aspect of software. Then trade secret protection should be checked. Then key IP transfer issues like assignment requirements, the contracts should be checked in respect of assignment clause, license innovation. You should take care of like whether license can be innovated. Then cross-border IP rights, employee inventions, if yes, then like how it has been transferred. And then briefly like data protection. Again, I would not repeat, but like that's mainly what you should take care about. Then cybersecurity, NIST regulation, security framework, incident response planning, and then like technical integration. And finally, some points I should mention, like in the UK, we have TUPE regulation. It's kind of regulation which regulates how employment should be done. So like during M&A, like all employees should be transferred from one company to another company with the whole protection around like whatever, like vacation, whatever employee has. And we have like very detailed regulations in this respect. And like, for example, in law firms, we have a separate department who's dealing with that kind of issues. Then we have obviously tax considerations. I would not repeat, but like one small point to know that in the UK we have stamp duty on top of any other taxes you have, because like obviously we have like capital gain implications, R&D tax credits may be concerned, VAT, but like again, like specifically, but yeah, apart from that, we have stamp duty. And like finally, like property and infrastructure, you should check lease assignments, data center considerations, digital infrastructure rights. And that's all apart from like normal due deal, which we're on. And normal due deal, I mean like analyzing all assets, analyzing all contracts, all debts, all liabilities, and everything around that. So basically, conclusion. Key takeaways: balanced regulatory approach essential, national security and innovation balance, post-Brexit considerations should be taken into account, and future outlook, continued tech sector growth, enhanced regulatory framework, competitiveness and recommendations, yeah, early regulatory engagement, comprehensive due diligence, and with different tech aspects to be taken into account, and stakeholder communication. Yeah, that's it.
Okay, thank you, Ina, for your sharing, especially from the perspective of UK law, where I think most of the speaker here have some connection with. So now we move to the third and the final speaker, Mr. Hinoshi Hinos, who is an alumnus.
Wait, Giang. I think
Yes.
Ina is also in a rush, so maybe she just answer the question in the chat box, and then you can continue with me.
Okay, great. So let's see some question for Ina first. The first question that I received from the box is, I was wondering, based on your experience as a solicitor in the UK and based in the UK, if the intervention from the government towards M&A tech sector, as I'm aware, geopolitics may play a part. How do you think about that, in your opinion?
Yeah, so in respect of interventions, generally government right now is intervening into like many areas, as you know, like because in Europe we have AI Act, right? And no one expected that. And like there are many kind of things happening in the UK. The government is very concerned about like fintech. That's why, like I would say, fintech is very regulated. Everything related to cybersecurity is also regulated. I would say like that's kind of like work for us, obviously. But apart from that, like I would say that's the what we should expect like to be on the market, because like governments are concerned about everything. And obviously, as you remember what happened with blockchain, yeah, so government started trying to regulate that as well. So we should expect that government will try to regulate as much as possible and to restrict some things. That's why like it's kind of like predictable. And I would say like given we are very similar to Europe in this respect, so we are like US, it's maybe a bit relaxed about that. Some small countries maybe, but like we are heavily regulated jurisdiction anyway.
Okay, thank you. And one question from me before you leave is that, do you consider the law and regulations in M&A in the UK is what encouraging for the innovation or becoming an obstacle for the innovation in the technology itself?
Yeah, thank you for the question, because like it's actually a twofold question, because like from one angle we have lots of restrictions, even like additional tax, duty tax, right? So it's kind of UK specific, meaning that like maybe it's not beneficial, but at the same time like common law basis means like a lot of flexibility, because like when we are dealing with like any kind of deal under common law jurisdiction, it means that we can draft whatever and we are free to regulate the way we want. And that's why like that kind of flexibility due to common law. On top of that, we have lots of R&D tax initiatives, and we have like some particular sandbox initiatives. All that give a kind of encouragement for companies, So that's why like I would say like it twofold, depending on the particular subsector, I would say, whether it's AI, whether it's like fintech, depending on like many factors. But yeah, generally, okay, still beneficial for anything. And you can see that even from the numbers, because like we have probably the biggest numbers of M&A in Europe.
Okay, thank you. Thank you so much for your sharing, and thank you for your time as well. I think that
Thank you.
the part.
Thank you.
Yeah, thank you. And now we can move to the final speech from our third speaker, who is, let me read about his biology, Hinosi Hinos, who is an alumnus of Queen Mary, University of London, with an LLM in Computer and Communications Law, graduating in 2013. Currently, Hinosi Hinos is a PhD student and a researcher in TMT, Technology, Media, Telecommunications Law at the University of Barcelona, UB, and also independent consultant in technology, media, telecommunications, law, and policy. PhD studies at UB began. Hinosi was a lecturer in ICT, Information Communication Technology, law modules at the Faculty of Law, UNPAT Indonesia, such as cyber law, media law, telecommunication laws, case study on technology, and e-commerce law. Hinosi's law in the technology, media, telecommunications law, TMT field started with his undergraduate studies at the Faculty of Law, UNPAT 2006, where he concentrated on law and technology. Hinosi in some organizations in the ICT area, local and global, such as ISOC and ICT IP Law Student Association at UNPAT. He was the lead country of University of London alumni ambassador in Indonesia between 2014 until 2022. Lastly, currently, the co-lead chapter of Queen Mary University of London, Indonesia since 2020, So now the floor is yours.
Thank you very much for your very kind introduction. Time really fast goes by. We already almost the end of it. Yeah. So let me share my slide first. Can you see my slide?
Not yet.
Not yet? Are you sure?
Not yet.
I believe I already share or the screen sharing.
Yes, I can see it now.
Yeah? Okay.
Yes.
Wait. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. May the blessing and guidance from God be upon us. Selamat malam, magandang gabi. Good morning, good afternoon, good evening. After 4 outstanding speakers with the practical experience, maybe this is time for maybe less serious about the topic, yeah, but it is actually broad if you see from the title of my slide. The role of merger and acquisition in the sector to determine human civilization. Okay, the title is broad. Why is that? Because we might, for many of us, probably thinking when we're thinking about merger and acquisition, we might only, especially when we say that only tech sector, we probably only think that as a singular business transaction. Well, that's actually not very true, especially when we are in digitalization, when we are in the era where technology have integral role. Yeah, actually, the merger and acquisition in the sector will have influence, impact, whether in the short, mid, long term, whether it applies in one country, in several countries, in the region, or even in global level. Because the nature of the technology, especially starting when we start from the use the internet, is borderless. Yeah, it's like the essence of the globalization itself. Yeah, it's domino effect. Yeah. I think there has been explanation about the trend of NMA. Maybe I just quick highlights, like some of the trend of merger and acquisition in the tech sector is, for example, one is companies starting to be more specialized in the subsector of technology, like cybersecurity, software, semiconductors, and the list is not exhaustive. Yeah, this is to strengthen their market, expand their product and service offering. And then we also seen this probably the classic one, yeah, where the big tech wanted to be more big. We wanted to be bigger than it is already, like GAFA, Google, Amazon, Facebook, Microsoft, Apple. Yeah, they're already big, but they expand. Yeah, they make deals to maintain their dominance in the market, drive growth and diversity their revenue stream. And of course, the innovation of technology itself is one of what makes the trend of NAE is continuing, yeah, from Internet of Things, blockchain, or even now artificial intelligence, yeah. The companies can do this by increasingly investing in the cutting edge technologies or by acquiring startups with innovative solution, or even by partnering with established players to develop and commercial new products and services. Then, because we're in the digitalization era, then we see that many sector that not necessarily initially tech sector, they done the M&A with the tech companies too. So cross-industry tech M&A like finance, healthcare, retail, automotive. Yeah, they're doing this because to integrate advanced technology into their operation to remain competitive in the digital age. Then we know the trend, and then we see the driver, right? The driver is rapid technological advancement, the competitive pressure, and the need for a market differentiation. Yeah, merger and acquisition can be a strategic tool to achieve market differentiation by acquiring unique capabilities, technology, and customer bases, and also from access to the intellectual property and talent, financial incentive, or even strategic alignment, focus more on core competencies. And I think the relation that whenever we do merger and acquisition, or we as even as the audience look at the parties of how merger and acquisition is done, we also need to look the bigger impact, yeah, For example, there are three parts. This is from the first part is the geopolitics and the sovereignty perspective. Why is that? Because technology now is critical asset in national security, economic power, and strategic competition, making tech M&A is become highly sensitive and prone to be intervened by the government. Yeah. I think from the national security and strategic control, we can see the critical infrastructure, including cybersecurity. And now with the AI and then military application that's being digitalized. And then of course, the classic one, the surveillance and data sovereignty is one of the key issue when M&A is occur in a certain jurisdiction. Yeah, because it will be related with geopolitics and the sovereignty of the country or even the region. And then we see economic sovereignty and tech wars. We already see trade wars in the normal one, and actually digital trade wars in digital economy is also happening. And we also already see many times tech national protectionism, where the application or the tech company is being forbid to have a presence in certain jurisdiction, or they are being limited to improve. Yeah, but some of the people forgot when the destiny is happened. Yeah, it's happened. Yeah, look what happened with DeepSeek. Yeah, the Western tried to block the development of AI in China, but they still make it. Yeah, they still make the DeepSeek. Yeah. And then digital sovereignty and strategic autonomy countries, for sure, for the sake of their national interests and national safety, they want to remain have a domestic control. Yeah, because when it's being dominated by foreign company corporation, it might contain other national country interests, which might endanger the existence of the country itself. Right. And then, of course, this is like we see probably the connection with the Taiwan about semiconductor. Yeah. And then this is also one of the start of the issue why internet's become very become snowball, become paradox. Yeah. Paradox become Pandora box, I mean, yeah, become a problem that never ending. And I think it is predicted that in the next few years, 99% of the content on the internet, it will be fake or at least biased. Yeah, it's because of the control information in the social media and the internet. Yeah, so in the past, before the internet and the internet exists, when people rely on television and radio, so we see that who controls television and radio is the one who can create the narrative, can control or the influence the society or even the politics in the country, and so on and so forth. But now it's shifted to social media, to what happened internet, and then artificial intelligence is just propelling more complex than it is already. Yeah. So, and then of course the problem is with the conflict of law and regulation between what happened in the national regulation between the region one, for example, European, what happened in Europe, and what happened in ASEAN, for example, and what happened in the NAFTA, in the North American area, third area, for example. They have different interests. Yeah, so this cross-border regulation also continue will be a problem. Yeah, so this might influence on how success of the M&A as well, and of course tech protectionism and national champions. Yeah, between how the government often want to promote their own national tech companies over foreign takeovers. We can see easy this if follow the news. Yeah. So we should look that when it's coming to M&A, yeah, from the geopolitics and sovereignty, it will affect national security, sovereignty, and global power dynamics. Yeah, because the government, because of that reason, government want to intervene and protect national security, ensure technological self-sufficiency. Yeah, maintain control over critical infrastructure, prevent economic dependence on foreign nation, because this is the key. We see how the country, when they are dependent on other country, they're being played, yeah, by the big country, the one who have influence. So we need to be careful on this. And the second part is about the merger and acquisition in the sector from sustainability perspective. We might forget that why we are doing M&A. It's about innovation technology. It's driven by innovation technology, of course. But why? It's because we want to survive. One of the key to survive in this planet, because we still have not find any other planet that is suitable for us is by promoting or implementing on consistent basis about the sustainability. So sustainability, let me remind, in the tech sector is about reducing environmental impact, improving energy efficiency, and adopting responsible business practices. So M&A in this case, it will be to advance the enabling companies to acquire green technologies, optimize resource, and comply with global government regulation. This can be done, for example, acquisition of green tech startup, and then investment in data center and cloud computing. As we know that the more we use the internet, the more, especially now with the use of AI, is the data center is actually creating more climate change than ever, because you just never know how the server is actually creating more hot temperature to the, it's like the concept of the air conditioner. I think for us, a common person, maybe we can convert like that.
Sorry, you have 4 minutes left.
Okay. So there is circular economy. Circular economy is about focusing, reducing waste, recycling materials, and extending life cycle of products. So NMA supports on circular economy should focus on this, how the companies should on consistent doing the e-waste, right to repair, because we probably do not realize that the problem that e-waste that we have these days is e-waste actually as difficult as a problematic as, for example, food waste. And then the digital economy, of course, the sustainability when we are talking is about how the finance, the fintech or the green digital finance, or how when we run, for example, startup, it can survive for long, not just burning the money and looks like success, like, but in the end, like just disappear. And so from the, in conclusion, for the convergence sustainability in digital merger and acquisition tech sector, from sustainable perspective, to reduce carbon emission, enhance digital sustainability, strengthen regulatory compliance, increase market competitiveness. And last but not least is about how the role of major acquisition in tech sector in combating inequalities. So this is really a double-edged sword of an M&A, because in one thing it can, because it can influence economic, social, and digital inequalities, because it can drive innovation and market efficiency, but at the same time it can also exacerbate inequalities, wealth concentration, digital access, labor market, and opportunities, economic opportunities. We can see how the monopolies, how the billionaire against the small business, venture capital startups, and it's still often the big, the winner, then the small is the loser. Then digital divide is, if M&A reflecting or have an impact on the deepened digital divide, then actually the M&A is a bad one, and I think it's getting worse. If nobody really cares about this, this is should the responsibility from the multi-stakeholder. Labor market, it is especially, it's we can see easily, the more advanced we use the technology, the more we will less human, for job. So this is really exponential issue, I think, we'll say, for job displacement. And then I think it's already been tackled by the previous speaker about the privacy issue and algorithm things. So I think what needs to be done from the government regulation, is to control the antitrust, policy intervention to reduce inequality, and then when the taxation should be redistributed, distributed for the program to combat inequalities, and of course about how we manage which one is public and private digital infrastructure. We just to focus on profit, we just make it as a private digital infrastructure, but we forgot that the access of technology nowadays actually becoming more close with human rights rather than actually become private rights. So anybody should have the access. So I think that's why the digital infrastructure should remain most of them public rather than private. So this is almost the conclusion. the future of tech, major acquisition in tech sector, yeah, from the inequality perspective is government, corporation, civil society, basically multi-stakeholder needs to strengthen the antitrust regulation, and I hope people, the government can do it in more consistent rather than and fair rather than being protectionist, yeah, and then promote inclusive innovation and then ensure fair labor practice and expand digital access. So in conclusion, yeah, given the crucial role of the technology sector in human lives nowadays, the M&A activities need to focus on sustainability, combating inequalities, and respecting sovereignty, so that the innovation and of technology continues to solve humanity issues and create a better quality of life to humanity. Otherwise, innovation of technology will become snowball, Pandora box, or even our own Armageddon. Yeah. I mean, if we quote to our teenager story back, yeah, maybe for the millennials, with great power comes great responsibility. Amazing Spider-Man. Or I'm modifying, great technology comes with great morality. Thank you for this opportunity. I will give the floor back to Giang.
Okay, thank you for your sharing. And let's move to the Q&A part. So in this part, while we're waiting for the question from the audience, I have one question for you right now. I hear you talking about the big and small dealer in the M&A, so and the monopoly as well. So is there anything that can be done by Asian and Southeast Asian countries in competing with the US and China in tech sector via merger and acquisition? What's your think about this?
Yeah, I think because sovereignty is one of the key issues here in so our independence as a country is defined by how independence we are, how we less dependence on other country. Although I think it's impossible even for China, who already, I think everybody think that agree that they already can make everything. Whoever make, they can make it. Yeah. But well, I'm not pro China, but I just feel like they have done remarkable in this past 20 years. Yeah. So I think for us from ASEAN country, from Southeast Asia, we need to work as a team, as a region, rather than work as a single. Yeah. So we should, how do you call it? The words is together we are stronger. Yeah. There are some changes, some challenges in ASEAN. For example, like we have some tech giants like Grab or Shopee, for example, like Gojek, but these three, for example, now nowhere near, for example, Google, yeah, nowhere near, for example, Apple, yeah. So we still have a long way to go. So I think if we can make a big tech company that not only strong in region but global, yeah, then we can start to speak. Yeah, but if not, then we more likely still like not a good competitor for them, and we still very much dependent or can be influenced by those two big countries, for example. So and also the other one is capital investment constraint. Yeah, and I don't know if there is any Southeast Asia country who can import, export semiconductor, like have advanced semiconductor like Taiwan, like US and China, for example. We need to start with this, and then I think this can be done through the diversity of ASEAN, yeah, but we don't know the procedure, how it works, because ASEAN works differently than European Union, where they can impose the harmonization of regulation and so on and so forth. Here in ASEAN, it's just you make a recommendation. Yeah. So we can see from the easy one is how data protection works in our region. You can see that there is no similar standard, right? Yeah, we might think that there is a similar standard, but it's different than the standard that we can see in European Union members. Yeah? You can see the French law about data protection in Spain is kind of, well, it's written in different languages, yeah, but the standard is the same. Yeah, but in our region, relatively not. Yeah. So
okay, yes, thank you for your opinion, especially on the part related to together we are stronger. As we are running out of time and we are already at the end of the session of the whole event, and on behalf of the joint organizer, which is the Center for Commercial Law Studies of Queen Mary, University of London, Distance Learning, TMT Indonesia, Philippines Chapters, and Hukomonline, I would like to say thank you very much for everybody's participation and contribution from the speakers, moderators, and of course the audience during this event. I hope from this event we can learn valuable things about how crucial the role and impact of merger and acquisition in the technology sector and shaping the digital economy. Last but not least, please don't forget to subscribe Queen Mary University of London School of Law YouTube channel and follow CCLS Indonesia Chapter program. Goodbye, everyone. Stay safe, stay healthy, and stay happy. Cheers. Bye bye.